Good morning, sir. You're Richard Vullery. And Mr. Vullery was previously in court and cause number 25 BCCR 1746, entered a plea of guilty to aggravated assault with a deadly weapon, a second-degree felony. And so was it unagreed as to the type of probation, but it was agreed that you would get probation, or just unagreed?
Correct, Your Honor. It was
Okay.
agreed to probation with the court to decide the type and length.
That's what I thought. It was just the way this is worded is a little, okay. And I've received that pre-sentence report. Have you both had an opportunity to review it?
Yeah, Judge.
I have, Your Honor.
Any additions or corrections?
No, not from the defense, Judge.
Judge, other than the court will recall the several times we've been here with respect to the bond issue. This is the one at the Chris Food Mart where we went back and forth on who could be employed there or not.
Yes.
With Mr. Collier, he had called and expressed concern several times. I spoke at length with the author of the PSI, Ms. Ramirez, and let her know my contact with Mr. Collier. And the court would recall that, so that she didn't have to feel like she needed to include all of that. That's why there's a little bit less of a statement from him in the PSI. Would ask that the court just take all of those factors into account and his expressed concern as well, and make sure that this individual stays away from him and also away from that location.
So I thought, though, that it got worked out where he's the one working there, not the other one.
Correct,
Right.
I believe so, but.
So the remain
guess
away
not
from the
the-
food mart, I'm not
I
gonna
guess
do.
not that, but that he remain away from the antique store that Mr. Collier may own. Is that true?
Yes,
Or
ma'am.
do you own that?
No, ma'am, I'm wearing the device to stay away from there and. it's,
Right.
Okay,
Sorry.
so do we know the address to that
I
place?
think we had it at the time of the bond.
Yeah, it was included
Magnolia.
It's on Magnolia.
exclusion for that with the GPS.
I have it.
Well, he has an exclusion for the Chris Food Mart because that's where you work.
Yes, ma'am.
And there was some issue at first on who got to work there, and you work there and he does not.
Right.
Okay, but this other place, I don't recall.
32 it was back in March, Judge. We had him trespass warned or admonished not to go to 3235 Pine.
Say it
Street,
again, I'm sorry, 30.
3235 Pine and 3265 Magnolia. And then at that point in time, you had 3090 Gulf, which is the food mart, which obviously
Right.
we will rescind that, I
Okay.
guess.
And these are all in Beaumont.
Correct.
Yes, ma'am.
Okay. Okay, anything else then?
No.
With regard to type of probation, Mr. Lewis?
Well, Judge, I know he has had some limit, criminal history there, but we still would ask that the court consider a deferred adjudicated probation on him. We think that definitely with his work history, working in the public and things of that nature, I think all of his history has been retail history. So which of course, if anything does change with his job history, it definitely will make it harder, of course, with a conviction involved. So we are asking that it be given a deferred adjudication.
Ms. Malfino?
Judge, obviously with this history, the state would have appreciated a straight probation, but more so I would like a lengthy probation. So I'd defer to what you deem is appropriate, but I would ask that it be lengthy.
So here's the thing, based on the nature of the offense and the fact that a firearm was used and exhibited, I am not inclined to give a deferred probation. I think the conviction gives us a little more control and hopefully protection with regard to the ability to possess a firearm, and that's important to me based on this. And so here's what I'm going to do, Mr. Vullery. I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence. Wait, I can't do it deferred, can I? On an ag assault? Can't, yeah.
No.
Yeah, we're just
Yeah,
having that issue.
yeah.
Well, never mind then. Here's what I'm gonna do. Should have figured that out when we took the plea. That would have resolved some things. All right, so Mr. Vullery, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to defer all proceedings and place you on probation for 10 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. One of those includes, obviously, you cannot possess a firearm at any time, at any place, for any reason. Do you understand? In addition to all of regular and whatever conditions of probation that they think are appropriate, you're also ordered that you cannot be at the location of 3235 Pine Street in Beaumont, Texas, and also 3265 Magnolia Street. Do you understand? And have no contact whatsoever with Byron Collier. So if you are anywhere else and he's there also, then you have to leave. Do you understand? Not just these two places, but anywhere else. I am obviously going to allow you, I think everything's still the same as far as I know with you working at the Chris Food Mart, that's fine. But if anything else comes up that is of concern of where he is, or if you think you're gonna get violated because he's somewhere, then you need to let your attorney know, like.
This is the moment the entire hearing pivots. The judge makes it clear that the use of a firearm changes everything. Even though both sides are discussing probation, the court is weighing public safety against rehabilitation. Notice how the judge is thinking several moves ahead, not just about punishment, but about future firearm restrictions and accountability. What do you think? Should a weapon automatically eliminate the chance for a lighter outcome? Or should every case be judged individually?
But the other side of that is if you violate any condition of probation, because it's a deferred probation, you could be brought back into court. You could then be found guilty of the offense, and I could send you to prison for anywhere in the range of punishment, which is a minimum 2 years up to 20 years. Do you understand? So I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You just need to have a seat here in the courtroom. Probation's going to call you to her desk when she's ready to go over your paperwork. All right. Good luck to you, sir.
Thank you. Good.
Good morning, sir. You Daniel Ward? And Mr. Ward was previously in court and cause number 25 DCCR 1375, entered a plea of guilty to driving while intoxicated, third or more. I've received that pre-sentence report. If you both had an opportunity to review that report.
Yes, ma'am.
Noodles.
Yes, Your Honor.
Any additions or corrections?
The only thing I would add to it is they've determined to be a moderate to severe risk. The issue that I have with that is that the bulk of his criminal conduct is 21 years ago
Right.
and 24 years ago. The last DWI that he had was 13 years ago. And what I would ask Judge is simply, I don't take away from what his history shows, but being that it's been 13 years before he's had any issues with drinking whatsoever. If the court is inclined to move forward with the JCDI program and various programs, I would simply ask maybe the court consider ordering it, but holding it in abeyance. And if he has any issue, any hiccup whatsoever while he's on probation, then implement that. But 13 years is a pretty good amount of time.
Well, I agree with you on that. The issue that I've got really is from that substance abuse assessment, which doesn't really have anything to do with the length of time or what the history is. It's just what's going on now and what their determination was. And their determination was severe alcohol use disorder as well as severe sedative disorder. And I think to make sure that he is successful, I am inclined to order what they have requested so that we don't have any
And
issues.
if I may, to say, I think I've always said the best indicator of future behavior is when you've done 13 years is an incredibly long time to go for anybody. So at the end of the day,
Well, how long have you gone?
I've gone for 61 years, Judge.
Right.
But at the end of the day, but for the grace of God goes I. And
Same here.
so anyway, whatever the court's wisdom, the only other
Thank
thing
you. I
would
appreciate
just
that.
add, he does have to do 10 days as a condition.
Yes.
He's full-time employed.
Okay.
We have asked that he do it on weekends.
Yes, no problem with
Thank you,
that.
ma'am. No
issue. So any issue with starting this weekend? It would be from Friday. You'll go in Friday at 6. They'll let you out on Sunday and you'll do that.
I mean, if you can do it, great. If not, she just needs to know a date.
Can I have like a 2-week notice, like not this weekend, but the following?
Are you working this weekend?
Yes, ma'am.
Okay, so here's what I'll do, Mr. Ward. I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time, find you guilty of driving while intoxicated, third or more. sentence you in accordance with your agreement to a term of 10 years in the institutional division of the Texas Department of Corrections, but I'm going to suspend that, place you on probation for 5 years. You're ordered to follow all of the rules and conditions of probation. That includes paying a $500 fine. You will be ordered to serve the 10 days upfront time, and I will do some dates on that in just a second. Also, I am going to order that you enter and successfully complete that JCDI program. I understand and respect what your attorney's asking for, but just based on the information that I have, I think it's important that you have those tools up front so that this doesn't ever happen again in 1 year or however many years. All right. So you will be ordered to complete that program.
And here's the reality check that every defendant in this courtroom hears. Probation is freedom with conditions. The judge is offering a second chance, but also laying out the consequences with absolute clarity. One violation could send him directly to prison for the full sentence. Interestingly, the court focuses less on punishment and more on preventing future mistakes through treatment programs. Do you think mandatory rehabilitation programs actually reduce repeat offenses, or are they just another condition people have to survive?
On time. If you're late, you can be considered a no-show. Obviously, if you don't show, it's a violation of your probation. It's very important that you don't. Some people think, and I know this isn't going to be you, that if they show up intoxicated, they're going to sleep it off for the weekend. Please don't do that. That's obviously a violation of your probation. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with your attorney, okay? You need to have a seat here in the courtroom. Probation is going to call you up to her desk when she's ready to go over your paperwork. All right, good luck to you, sir. Thank you.